Hello guys, good morning. I hope you guys are done with your marathon. Concepts are all clear and you have straight away come from there to the most important topics. So the most important topics is nothing but, see, there would be a pattern that the questions would have been coming from or the most repeated topics from your exam point of view. And if you look at if the board, if they have taken up most indirect based questions and all, so what will be those topics be? So from that point of view, I have created this. Remember, this is not a substitute for, again I'm telling you, this is not a substitute for your regular classes. Do not think that I read this and go, then it will be more than sufficient. No, I'm saying last second, do not miss out these things. It will be very important. So agenda for the day, I'll try to tell you which is what, because I have just done with marathon. Yesterday only you guys have watched it also. Again, me explaining all of this wouldn't make sense unless and until somewhere it is really required. I don't mind explaining those concepts. If not, I'll try to just tell you these are the important topics. Try to focus on these areas. Clear, all of you? Let us try to keep it as short as possible. You want this PDF? Okay, I'll try to upload this PDF as well. You guys can have it for your reference. So yes, let's begin. Okay. Indian regulatory framework. I've tried to give you the weightage also here, people. You can expect one question for sure from Indian regulatory framework. And what type of question will it be? The question will, most of it will be, people, source of law. Now, when I say source of law, they will not give you the entire thing. They will not ask you, which one is the, write down everything. They might not ask you. They might ask you to write about criminal law. They might ask you to write about civil law, common law, or principles of natural justice. So they can ask you that specific thing. They might not ask you to write down entire thing for 4 marks. No, 99% no. Or they may ask you to write about any 2 types of laws. Yeah, that is one possibility. Yes. Okay. So that is one thing. Next one, sir. Next question is, people, process of making law and types of law. What are types of law, sir? That is what we saw. Next one is process of making law. What is process of making law? How is a law made? First, a committee will be formed, a specialized committee in that subject matter. That committee will submit a draft bill. The draft bill will be submitted in both the houses of parliament, Lok Sabha and then Rajya Sabha. In both the houses, you need to get a consent. Once you get a consent in both the houses, the bill will now be given to President of India to sign. Once the President of India signs, how will you and me know? It will be then published in Official Gazette of India. Once it is published in Official Gazette of India, the law will be final. That will be the process of making law. I hope you agree. So try to remember that. Each of the executive is a possible question. What is that? You guys have Ministry of Home Affairs, Ministry of Corporate Affairs, Ministry of Finance. So in that I have taken these 4 as some specific topics which they can always ask you. One is IBBI. What is IBBI? Insolvency and Bankruptcy Board of India. From an exam point of view, it is important. They have asked also once. Now, why is IBBI important? What is IBBI, people? Nothing but just like your ICAI is governing you guys. You guys are there, no? In the same way, there is something called as insolvency process in India. It is governed by Insolvency and Bankruptcy Code. Now, just like chartered accountants, there is insolvency and bankruptcy also. Imagine it is like a law. Now, under Insolvency and Bankruptcy Code, now here your Chartered Accountants Act is there. Who is regulating the Chartered Accountants Act? Someone has to regulate it. You have ICAI. In the same way, the person who is regulating Insolvency Bankruptcy Code Act, the person is called as Insolvency and Bankruptcy Board of India. Now they regulate it. So, sir, ICAI is regulating whom? It is regulating your act. It is regulating your Chartered Accountants. All of that. In the same way, in Insolvency and Bankruptcy Code, there are a lot of people that work. All of them will be regulated by this Insolvency and Bankruptcy Board of India. First of all, what is IBCDA? Imagine if a company is under liquidation stage, or if a company is unable to pay its debts, the company will either have to die, or the company either have to compromise with its creditors. So this entire judgment will happen in one place, and that place is called as Insolvency and Bankruptcy Code. That in that act, who regulates it? It is regulated by IBBI, Insolvency and Bankruptcy Board of India. So remember and go. Next one, sir. What else is our important? MCA, Ministry of Corporate Affairs. What is Ministry of Corporate Affairs? See, wherever people, if you look at it in the center at the top, we have central government, correct? Central government cannot carry on every function, right? Every department cannot be taken care by one person. Modi cannot sit and say, I will only take care of that, this and all. Not possible. So what does central government do? Central government will divide its function into various departments, and we call the departments as ministries. Like Ministry of Finance is one of the ministry. Ministry of Corporate Affairs is one of the ministry. So like that, one of the ministries is called MCA. The head of MCA is Nirmala Sitharaman. The minister of MCA is Nirmala Sitharaman. MCA only governs your Companies Act, LLP Act, as well as Insolvency and Bankruptcy Code. So these three acts will come under MCA only. That's why important, remember. Next one, Ministry of Finance. Ministry of Finance also, they may ask you, because I'll tell you the logic behind me saying why Ministry of Finance is important. Because end of the day, macha, it is yours, no? Something where your entire industry is, revolving around. Ministry of Finance is so important for you guys. That's why I said logical. So that's why I'm telling you, try to remember and go. Yeah. So under Ministry of Finance, there are various other departments also. Examples: Department of Economic Affairs, Department of Expenditure Revenue. What is this? Who takes care of the earnings of country? Who takes care of the spending of the country? That is these two. Department of Financial Services, meaning again, who takes care of the financial services of the country? Department of Investment and Public Asset Management. So we have extra money. If at all we have, who will invest? Where to invest? How do we know? Department of Public Enterprises. Our public enterprises, how will it be regulated? So all of that. So try to remember and go. Ministry of Finance, they may ask you. RBI, again, because it is to do with banking sector, regulator of bank also takes care of printing of notes in some cases. So all of that will come under RBI, one of the regulator. Important, remember and go. Structure of Indian judicial system. Again, a question where they can ask you. Indian judicial system is nothing but, they can ask you what are the functions. One of the questions that they have asked, initially 2 times they have asked. So what is the function? To regulate interpretation of acts and codes. Whenever there is a confusion in the law, the judge's duty is to interpret it, meaning how to understand it, he will tell you. Dispute resolution. Whenever there are fights, the judge will always give you the judgment. Promotion of fairness. End of the day, we have to be all equal, fair and all that. Don't cheat. Types of courts they can ask you. Supreme Court, High Court, District Court and Metropolitan Court. Supreme Court is the highest to apex body of the country. Apex body means people topmost. So whenever your fundamental rights are infringed, you guys can directly apply to Supreme Court under Article 32 of Constitution of India. High Court, whenever you guys feel for a state, the highest authority is people's High Court. If at all your fundamental rights are infringed, you can either go to Supreme Court or High Court. To Supreme Court under Article 32 of Constitution of India. To High Court under Article 226 of Constitution of India. Next one is District Court and Sessions Court. Now, district courts generally deal with civil matters. Criminal courts, Court of Sessions deals with criminal matters. So if you have any problem with regards to money, imagine breach of contract, you will first come here. If you are not happy, from here you will go here. If you are not happy, from here you will go here. This process only we would have seen in class as appeal. Now wherever there are cities, metropolitan cities and all, where number of people are more, in such cases, we will specially nominate certain courts there. We call such courts as metropolitan courts. Metropolitan courts is nothing but people where the cities have population of 10 lakh or more will have a special court for themselves. In addition to this, we also have tribunals also. Tribunals are nothing but specialized quasi-judicial bodies. set up under each act, which take care of the matters coming only from those acts, is called as what, people? It's called as tribunals. Done. So try to focus on these questions from the first chapter. Chapter 2, weightage 25 to 30 marks. So people, Dilka Dadkan, I've been receiving lot of messages that, sir, I have not concentrated at all, I have not studied at all. Even if I start now, can I still pass? People, I would say it is always okay to try than to give up. I would still say it is possible. Go sit. Never come out of the exam in between. That's one thing you guys have to do. Complete your paper. And do not, just because one paper went bad, do not get demotivated for the next paper, because you never know until the result is out. Remember, you are in the game. Always remember that. Until the results are out, you are in the game. So don't give up. Clear? Okay. First unit, nature of contract. What is a void contract? What is void contract? A contract which is valid at the beginning, which becomes invalid later on due to change in law, due to death, due to, change in subject matter, due to operation of law, impossibility of performance, subsequent impossibility. It is called as void contract. What is voidable contract? A contract which is void invalid, void at the option of one party and not at the option of other, is called as voidable contract. What do you mean by voidable contract? A contract which can be either valid or invalid, which can be this or that at the option of one person, is called as what, people? Voidable contract. So remember, these three are important. Next one is difference between void and voidable contract. Difference between void and voidable contract. They can ask you that also. Remember and go. See, a contract ceases to be enforceable by law, becomes void when it ceases to be enforceable. Meaning what? It is no longer enforceable by law. It has come to an end. So a contract which ceases to be enforceable by law, it is no longer valid, it is called as a void contract. It has come to an end. Voidable, people, an agreement which is enforceable by law at the option of one or more of the parties, but not at the option of the other, is called as voidable contract. Remember, where we go wrong in exam, we try to write examples whenever they are asking us the meaning, definition and things like that. When they are asking us meaning, when they are asking us definition, we are expected to at least write what is here. We cannot just write an example, right? I know we would have understood the concept. I cannot write whatever that is completely in my own words. That will not be valid. See, here and there you can use, people. Here and there you can use your own words. I'm not denying the fact. But whenever they're asking you a definition and all, you are expected to write what is written here. Agreed? A void contract cannot be enforced at all. It will definitely come to an end. It is enforceable only at the option of aggrieved party. What if a party chooses the contract to be valid? In such case, it will be valid contract. Always remember, Indian Contract Act, Sale of Goods Act, even for Partnership Act also, whenever they're asking you a direct question, don't mind writing an example. Write one example. Clear? A contract becomes void due to change in law or change in circumstances beyond contemplation of parties, which we cannot control, like death, change of law, etc. A contract becomes voidable if the consent of a party was not free. Agreed? Example, what, people? Now, for example, I will force you to sell me your bike. I'm forcing, I'm threatening you. I'll tell you, if you do not give me your bike, I will shoot you. Now, because of that threat, you have given me your bike. Now, should I consider this contract as what? Void, valid, voidable? People, it is voidable. Now, imagine, I will make you sign all the papers. How will the world know that I took your signature with force? How will the world know? The world will know based upon the option you choose. You have an option to either go to the court and say that, sir, this contract was entered with me by force. You can do that. Or you keep quiet. You be as if nothing happened. If you be as if nothing happened, people, then we consider a contract as valid contract. A void contract cannot be performed if the agreed party does not within reasonable time exercise his right to avoid the contract, go to court, say, sir, this signature was taken by force. If you go, it will be cancelled. If you do not go, it will be valid contract. A void contract does not grant any legal remedy. The party whose consent was not free has the right to rescind the contract within a reasonable time. So here you do not have any remedy. The contract will come to an end. Imagine any benefits given, you have to return it back. Here people, the contract is voidable only if you choose to decide it so. But of course, if you choose to decide it to be void, then also, yes, people, whatever benefits you have taken, you will have to return it. Yes, sir, these are the differences, sir. Okay. Implied contracts. Example, people remember, they can build you a case-based scenario under implied contracts. What are implied contracts? A contract which is entered based upon the conduct of the parties and not based upon the words spoken or written. So the contracts which are entered by the conduct of the parties is called as implied contracts. They can ask you case-based scenario, indirect based questions here, remember and go. Executory contracts. What do you mean by executory contracts? There are two types of contracts. One is people called as executed contract, one is called as executory. What is executory? Whenever any obligation of the parties are pending in a contract, it's called as executory, meaning something is to be done yet. If at all both the parties are yet to perform, we call it as executory bilateral. So if at all in a contract, if at all there is both the parties obligation pending, we call it as bilateral. If only one party's obligation is pending, we call it as unilateral. Unilateral means what, people? Chart books, they go and see there in the marathon. So I've given this chart books for free. Go and take it from there. Okay. Executory contracts. Unilateral means people, one party's obligation is pending. Bilateral means people, both the parties' obligation is pending. Okay. Executory contract. Next one, people, types of offer. What is types of offer, people? In types of offer, we have different types of offer. They may ask you a question. Express, they won't ask. General offer, they may. What is the general offer, people? Offer made to public at large. I'm not going to deal cases now because we'll be doing case laws tomorrow. So complete cases in your ICAI book I'll be discussing. So currently leave it. Specific offer means what, people? An offer made to a specific person. In a specific offer, always remember, acceptance has to be given by the person to whom the offer is made. Cross offer means what, people? An exchange of identical offers is called as cross offer. I will tell you, will you buy my car? You will also ask me, will you sell your car to me? Now I am also asking you to buy, you are also asking me to sell. But remember, both of us have asked questions. None of us have given a reply. Hence, people, cross offer is never a valid contract. Next one, people, counter offer. What do you mean by counter offer? Whenever you give me an offer, if I change any terms of that offer, the first offer will come to an end. The second offer will precede the first offer. You ask me that, can you buy your car for 5 lakh rupees? I will say I will buy it, but I will buy it for 4.5 lakh rupees. So I'm saying yes, sir, but I'm saying price I want a negotiation. Now the offer will be substituted. Your offer will come to an end. My offer will now precede your offer. So now you will have to give an acceptance. Next one is called standing or a continuing offer. Meaning I will tell that the offer will be valid from, say for example, 10th of September to 20th of September. When an offer is open for a certain period of time, we call it as a standing or a continuing offer. But remember, I told that the offer will be open from 10th to 20th. If I want, I can cancel the contract, people. I can say I do not want to continue with the offer. I can take it back on 8th only. Until the offer is accepted, I am free to cancel it. They can ask you a question here. Remember and go. Okay, offer is different from invitation to an offer. So they can ask you that question. Offer is different and what is that? Invitation to an offer is different. For example, people, mere quotation of price cannot be considered as an offer. So I will ask you, what is the least possible price you will sell me your bike for? You said, if at all the day I am selling, I will sell it for not less than 1 lakh. I will say, yes, I accept. So just a quotation of price is not considered as an offer. It is just invitation to an offer. Next one, advertisements in newspapers. Imagine what is that? The items kept at display in the shop. It is an invitation to an offer. Just because in the showpiece, if they have kept one particular cloth and they have said it is a sale, you go inside, that cloth is no longer there, out of stock. You cannot file a case. Hey, you have kept a product there and you have put a sale. Why are you not selling? It is an invitation to an offer. That is not an offer in itself. It is just inviting you to make an offer. You come inside and you ask for it. If it is there, we will give it to you. So the goods kept at display is just an invitation to an offer and not offer itself. And tender. We giving you an advertisement. We giving an advertisement that come and participate in a tender is just an invitation to an offer. Imagine I told you the offer, the tender will be conducted on Sunday. And whatever is a tender, people, later on I cancelled it. Now you want to file a case on me. Can you win? Answer is no, you will not win. Because I have just given an invitation that come and participate in the tender. I have not yet agreed to sell my articles to you. Agreed, all of this is considered as invitation to an offer. Invitation to an offer, very important. Remember, and go, they can ask you a question, pakka. Next one, specific offer, specific acceptance. Whatever we saw, specific offer. An offer made to a specific person. If it's a specific offer, acceptance has to be made only by the person to whom the offer is made. Boulton versus Jones, case law also is there. And rules of acceptance, people. Read and go all the rules of acceptance. What is all the rules of acceptance? Mere silence is not acceptance. Acceptance has to be unqualified. Acceptance need not be adequate. It need not be same. So try to read all that and go. Yes, important. Next one, completion of offer and acceptance. When is the offer complete? When is the acceptance complete? That can also play an important question. From exam point of view, important. So, when is the acceptance complete? When is the offer complete? When is the acceptance complete? Offer is complete when it comes to the knowledge of the person to whom it is made. A told B that I want to sell my car to you for 5 lakh. Imagine if it is sent by letter. The moment people B reads it, whenever he reads it, offer is complete. When is acceptance complete? Acceptance is complete from two people's point of view. From B's point of view, from A's point of view. From B's point of view, when is the acceptance complete? From B's point of view, the acceptance is complete when A reads his reply. Imagine, people, B has said, yes, I am interested. Whenever A reads it, now it is considered as acceptance is complete. From whose perspective? From B's perspective. Sir, from A's perspective, when is acceptance complete? From A's perspective, the acceptance is complete whenever B replied yes. And imagine he has put it in a postal dappa. The moment he puts it in it, from A's point of view, acceptance is complete. Is clear? Pakkana, this is the perspective. From proposer's point of view, from acceptor's point of view. And remember, this scenario will come into picture only and only when people in a telegraph or postal cards, only in that scenario this can come. When two parties are standing next to each other, all this nonsense will not come at all because it will be instantaneous. Always clear, pakkana. And also remember one more thing. If at all we are entering into a contract on a telephone, when is the acceptance complete? Now imagine, sir, there is one more scenario also. There is an offerer A, there is a B, acceptor. A gave an offer to B that would you want to sell my car? B said, yes, I want to sell your car. A is from Bangalore. A is from Bangalore. B is from, let us imagine, people, somewhere, Hyderabad. Andhra Pradesh, Telangana, sorry. So, B is from Telangana, Hyderabad. So, B said yes. Now, A is in Bangalore. Let us imagine the contract is happening over telephone. Now, the question is, what will be the jurisdiction? Imagine tomorrow if there is a dispute, any case, where should we fight? Is it in Bangalore's court or Hyderabad's court? Always remember people, the jurisdiction will be where the acceptance is heard. Where is acceptance heard? Acceptance is heard in Bangalore. So the jurisdiction of courts will be the Bangalore. This happens only in the case of telephone. Is this clear all of you? Pakka? 100%? Know it and go. Next ones are modes of revocation of offer. How and all offer can be revoked. Easy one. By notice, lapse of time. I'm sorry. Okay. By lapse of time, by non-fulfillment of condition precedent, by death or insanity, by counter offer, non-acceptance in prescribed amount, subsequent illegality. Yeah, everything we have seen it in marathons. Again, I'm not going in detail, but know and go. Done na? That is your unit 1. Know these things and go. I think important from exams point of view. And also try to read that, what is that? Sir Williams, this one, the metaphor. What is gunpowder to the matchstick? Read that also and go. Consideration, definition, people. Definition, read and go. The definition also includes its rules only. So there is nothing that comes out of picture in consideration. If you know definition, you will know rules of definition also. Rules of the condition also, consideration also. Okay. So what is the definition of consideration, sir? When at the desire of the promisor. So it always should be at the desire of the promisor. Case law. Durga Prasad versus Baldio. The promisee or any other person. Who can give consideration? Is it only the parties A and B? Who can give? A can give, B can give, or some third party on behalf of me can give. Example, Chinnaya versus Ramaya. We will be seeing this now. Who can perform the contract? Promisor himself or an agent or a third party. Anyone can perform. A person who has done or abstained from doing or does or abstains from doing, promises do or abstain from doing. Meaning what, people? What do you mean by done or abstained? Meaning anything positive also can be consideration. Anything negative also can be consideration. Asking someone not to do can also be consideration. Such an act or abstinence is called as consideration. Yes. Okay. Next one, people, exceptions to quid pro quo. I'm directly going because of the topic. These are the things that you can expect. Of course, all these are important. I'm not saying no, but yes, pay some more attention towards exceptions to quid pro quo. What is exceptions to quid pro quo? Meaning what, sir? Generally, sir, quid pro quo means what, people? Give and take. That is, in every contract there has to be giving and taking, but there are some agreements where this quid pro quo is exempted, which is that first one, natural love and affection. When you're writing, when you're asking in the exam, make sure you write all the rules. When will natural love and affection come into picture? Near people should be from near relationship. The agreement has to be in writing, and the document has to be registered under the law. Only then it will be valid. Next one, compensation for past voluntary services. Meaning, sir, imagine I helped someone. That person promised me to compensate 500 rupees. It becomes a legally binding contract. I can go and file a case on that person to recover that money. Like, for example, imagine someone lost his purse. I went, I searched, I gave it back. He promised me to give me a reward of 500 rupees. Now it becomes a legally binding contract. I can file a case on him to recover. That is called past voluntary services. Next one, the promise to pay a time barred debt. A debt which is time barred. Meaning, generally, if you want to recover the debt, you need to go to the court within 3 years. Now, if I do not go to the court within 3 years, technically, as per the law, it is called as a time bar debt. But imagine if someone comes and promises to repay that also. That is, it is actually time barred, it is done. Again, he is coming and promising that I will repay. So, for that, you do not need to have a second consideration. It will still be valid. Next one is people agency. To create an agency, people, you can even your own relatives can be your agents. Of course, not every time it will be for money. If you imagine if your father is acting on behalf of you, will they charge money for it? No, it is called agency. Completed gift. Of course, in gift, where will be this one consideration? Next one is bailment. We'll be seeing, and charity. What is charity, da? In charity, of course, there is no quid pro quo. You will say, I will donate money. What will you get in return? Nothing, no. It is still an exception. But remember, Kedarnath versus Gori Mohammed. Charity will not be binding on you unless the other party has undertaken any liability based upon your promise. If for example, I said that I will donate some 10,000 rupees for some child's operation. Based upon my word, if they have taken up this operation, if they have went and admitted the child in the hospital, I cannot cancel my 10,000 rupees charity. I have to give. So based upon your word, if the other party have acted upon, then your contract will become solid and binding. You cannot go back. Is clear? Okay. Done now. Next one, sir. What is the next one? Next one. Quid pro quo, done. Other essential elements of a valid contract. Rules of minor contract, people read and go, completely important. Minor contracts cannot be ratified. If at all there are two parties in a contract with a minor, imagine if surety is there. Surety will be liable even if a minor is a borrower. And if there is a co-surety, or if there is two parties who have borrowed the loan, minor and a major will be liable to repay the entire loan. And the minor cannot bind the parents. Minor will be liable for necessities. Not only minor will be liable for necessities like education, shelter, food and all. But personally Allah, his assets are liable. Minor's assets will be liable. If assets are not there, minor's liability will not come into picture at all. Moheri Bibi versus Dharmodas Ghosh. So remember and go, rules of minor contracts are important. Next one, people, difference between coercion and undue influence. What is coercion? What do you mean by undue influence? Coercion means nothing but people where some force is involved, like threaten, extortion, exploitation, kidnapper, anything, people, basically which is punishable under Indian Penal Code, IPC. You have done something called as coercion. Undue influence means what, people? Undue influence means people, I will not be punished for whatever I have done. Example, imagine if I'll tell you, if you guys do not sell me your bike, I will fail you in your exams. I will not give you this 5 marks. That is called undue influence. It's a threat only, but this is not life and death threat. So this is also not a valid contract, but for this I will not be punishable. If I say I will not give you 5 marks, for that what, you will hang me or what? Yeah, so for that I will not be punishable. So undue influence is that. And one more difference, in undue influence there is always relationship between the parties like employer-employee, master-servant, teacher-student, and always one party is in the dominant position and the dominant party will always take advantage of his position. That is only called as undue influence. Next one is fraud. Important again. What is fraud? Mere silence is not fraud. Of course, a party can remain quiet, but if it is your duty to speak, you have to speak. A contract of Uberima Fidus people is a contract of utmost good faith. In these contracts, you have a duty to speak. Even silence amounts to fraud, like marriage, prospectus. So, insurance contracts. So, these examples are examples for Uberima Fidus. In these examples, even if you stay quiet, where silence only, where there is a duty to speak, in these cases, the silence only will amount to fraud. Okay, next one, legality of object and consideration. What is legality of object and consideration? Important here, you need to remember, what is that? All your forbidden by law, stifling, all that. When is consideration opposed to public policy? This one. Stifling of prosecution. What is stifling of prosecution? You should not trade with your family. Meaning, if at all there is any crime, you cannot go and settle it. You are not supposed to do that. Yeah. And maintenance and champerty. What is maintenance and champerty? Maintenance and champerty means, people, whenever someone helps you to to fight a legal case. In return, if they are expecting something, if they are expecting reasonable, it is valid. Whatever they are expecting in return, if it is unreasonable, then maintenance and champati will be opposed by public policy. Yes, so remember these and go. It is important. Yeah, trafficking relating to public office and titles. Meaning what? I will sell you Padma Bhushan, Padma Vibhushan. I'll sell you the you want to become commissioner. I'll give you 10 lakh rupees. I'll say. So such things can happen. Illa bribe and all not possible to get government jobs. You are telling you. Agreements creating monopoly. You cannot do. Two big giants in the industry coming together. If they are killing competition, then of course no. Imagine Airtel and Jio comes together now. Correct? Marriage brokerage agreements. Interference with course of justice. What do you mean by interference with course of justice? Imagine people. I will go and buy the witness. I will go and buy the opponent lawyer. I'll give him some bribe. I'll tell him not to come tomorrow. All this you are not supposed to do. Yes, sir. Okay, remember those and go. And of course, people wager. So remember that horse race, puzzles, crossword puzzles, 1000 rupees, and horse race, 500 rupees, and speculative transactions. And remember, whenever it is a game of skill, it will be valid. So remember those parts and go, important. Next one, performance of a contract, rules on joint promisers. So joint promisers, remember, important and go. I'm telling you in addition, for this attempt, you remember that and go. Who can perform the contract is definitely important. A promiser himself or third party or agent or legal representative. Remember, it is important, but I'm telling you, for this, you just try to read this and go. Rules on joint promises. What is joint promisers rule? Whenever we have taken 3 lakh, we have to return 3 lakh only. If at all any joint promiser dies, the legal representative of that person along with the rest of the remaining joint promisers will have to repay. Sir, if no one is there, then the joint promisers will have to share the loss. But of course, they can recover it from the person who is unable to pay now. I can recover the money from him. So remember that and go. Appropriation of payment. What is appropriation of payment? Whenever I have taken multiple debts, if I am returning that, the order of repayment first will be decided by debtor, or if not debtor, it will be decided based upon circumstances. Meaning what? I have taken 1 lakh, I have taken 30,000, I have taken 2 lakh. When I am specifically repaying 30,000 and I have 30,000 loans specifically, and debtor does not say anything, you have to make sure circumstances say, I have taken 30, I am repaying 30, so take it towards this 30,000. Sir, what if debtor silent, circumstances does not say anything? Then people go as per creditor's choice. Whatever creditor wants, he can do. The last one is people. You go in the order of FIFO, first in, first out. Whichever loan was first taken, it will be set it off towards that. Next one, sir, discharge of a contract. When and all contract will come to an end? By performance, by mutual agreement, by impossibility of performance, breach of contract. So all that scenarios, remember, important from exam point of view. Next one, sir, unit 5, breach of contract and its remedies. Remedies for breach of contract. Everything is important, but pay more attention when you are seeing damages, because case-based questions can come from damages point of view. Yeah. Suit for damages, important from exam point of view. Specific performance, they can ask you later point of time. And quantum merit. Here these two will be very important. Remember and go. Sir, even in damages also, they can ask you some special scenario here. General damages, special damages. Whenever no extraordinary conditions are communicated, you are not entitled for any special damages. Hadley versus Baxendale. But if at all some special conditions are communicated, I am entitled for that particular thing as well. Like for example, in a case of that Hadley versus Baxendale. So I had a particular, let us imagine people, now this mic is under repair now. I go to a person and say that, can you please repair this mic and give it to me? He says, yes sir. I ask how many days? 2 days. I say okay and I come back. After 2 days, people he does not give me. 5th day, people he does not give me. 10th day, people he does not give me. Now what am I entitled to? After 10 days he will give it to me. I am entitled to something called as general damages. There is delay. For that, how much ever is required, they will give it to me. Now what will I say? Hey, because you did not give me the mic, my classes were on halt. I could not take the classes. So 10 days I lost some admissions because of you. Give me the money for the entire thing. Can I ask? No. But imagine if I told him, hey, remember my classes are on hold. There are some 5 people that are joining per day. If you do not give it to me, then I will not be able to do classes. If I have told you this, people, it will come under special damages. Remember. Next one, vindictive or exemplary damage. What is vindictive or exemplary? Nothing but people revenge. This will be ordered in the case of wedding. You promise someone that I'll get married to you, and if you do not get married to them, vindictive will come into picture. Next one is people wrongful dishonor of customer's check. Meaning people, remember in case of exemplary damage, if at all you need exemplary damage, meaning you will get little good money. If something like this happened, meaning my bank has account, my account has money. In spite of having money, people, the bank said your account does not have balance. In such case, people, I am entitled for something called as exemplary damage. But remember, this will be given only to a businessman. But if a normal person wants it, you need to prove that because of this wrongful dishonor, my status, my symbol and all was affected. You have to prove to get exemplary. Or else people, generally, if you are not a businessman, you are not entitled to exemplary. You will get nominal damages. Remember this. Because a few people will ask, sir, what if I was not able to prove? Or what if you and me, sir, my check is bounced. I earn nothing, sir, no impact at all. For that, why do I exemplary, revenge, big words and all? We will come under nominal damages if you are not able to prove. Or imagine if there is no damage occurred at all, but still it is a problem. What it is not right. For that you will get nominal, not exemplary. Nominal means what? Something reasonable, that's all. Yes, sir. Last one, people, prefixed damages, sir. Difference between liquidated damages and penalty. Remember, important and go. Nothing but people, if at all the damages are already fixed in your contract only, we call it as prefixed damages or liquidated damages. In Indian code, there is no difference between penalty and liquidated damages and all. But what is the actual difference in in the English codes? What do you mean by that? Remember the numbers you have written in the contract. If at all there is a breach of contract, you will have to pay me some 1 lakh rupees. If this 1 lakh is reasonable, we will call it as liquidated damages. If this 1 lakh is arbitrary, absolutely unreasonable, how did you calculate? No sense at all. I just put 1 lakh. In such case, we call that particular word as penalty. But remember, in Indian courts, they will never order you more than what you guys have suffered. So it's always actual loss versus agreed loss, whichever is less. Don't write in the exam, but yes, that is what we would have seen in the class. Okay, done. Quantum merit means people, as much as performed, they can ask you questions there also. Remember and go. Unit 6, quasi-contracts. Quasi-contracts important. Remember on quasi-contracts. What are quasi-contracts? Claims for necessaries, that is minor, unsound mind, and also remember, if there is any dependent upon them, meaning, sir, our entire family passed away. One minor and one grandparent of that minor. Imagine people, his probably, what do you call? Grandparents, one of the grandparents survived. The grandparents' age is, let us imagine, is 85. They can barely walk. This minor is of age 16. So, who is conscious? Now, if the entire family passed away. So, it is his responsibility to take care of this person also. That is grandparent. So, anyone who supports this minor, they can recover the money, not only for his cost, even for the grandparent's cost also. Yes. Payment by interested person enjoys non-gratuitous act basically by mistake. Finder of lost goods, money paid by mistake or coercion. Remember this, quasi-contracts important. from your exam point of view. Okay. Next, yeah, I hope you guys are understanding that. I hope it is something is going inside. Yeah, and if I go again in detail down, it will become hammering. So wherever I possible, I'm telling you, this is what it is, this is what it is, just know that and go. Okay, Unit 7, contract of indemnity and guarantee. Types of guaranteed, that is nothing but specific guarantee and continuing guarantee. They will ask you a lot of questions around continuing guarantee. Can you revoke continuing guarantee? Is it possible? What do you mean by continuing guarantee? Guarantee given for series of transactions or for a certain period. So continuing guarantee can be revoked, but remember only you can revoke the future transactions, not the past transactions. That is not possible. Clear? Nature and extent of surety is liability. To what extent is a surety liable? People remember, surety is always liable coextensive with the principal. Meaning if principal has to pay principal and interest, meaning if the borrower has to pay principal and interest, surety also will have to pay principal and interest. If principal has repaid any loan, in some installments have been repaid, surety's liability will always reduce by the installments that has already been paid. Correct? So all that remember. Next one, discharge of a surety. So discharge of a surety by revocation. This is again okay. Future only can do, past cannot be done. By conduct to the creditor, they can ask you a question here. That is, if the imagine creditor has not disclosed any material information, or if there is any concealment of a factor. You remember those scenarios? If at all such things happen, people, of course, the thing will come to an end. The next one is misrepresentation. This one, if you remember, concealment, all that. So remember and go. These things can be important from your exam point of view. By conduct of creditor and by invalidation of contract of guarantee. The last one is rights of surety against principal debtor. Important. Meaning, sir, if a debtor does not repay the loan, the surety will repay the loan. I can recover it from the debtor. This principle is called as principle of subrogation. Next one, against the creditor, what will be my right? Right to benefit of creditor security. If my borrower has given any, collateral, security, any gold, whatever is the value, even my value will reduce by that. Right to set off. What do you mean right to set off? Right to set off means, people, if at all the principal debtor has paid 5 installments, what I need to pay is, you deduct that 5 installments. Whatever is the remaining, I need to pay that. Right to share reduction, meaning imagine if the principal debtor has become insolvent. You go and recover some money from his personal assets. Whatever you recover, my liability will also go to an end from that. Against co-surety, what is my right? Remember, this is very important. In marathon, I have clearly given you how to calculate this also. If nothing is told, then you have to divide the liability equally. Or you will, if it is different proportions, you will divide it equally as far as the proportion allows you to do. Please watch marathon here. I have given you examples, various examples. It's always a possible practical based question. Yes? Okay. Next one, bailment and pledger. Finder of lost goods. Finder of lost goods, what is your right? Can you sue the other party to recover money? Imagine, people, I found the wallet. I found someone's purse. Yeah? And I'm going and give it to him. I'm asking him, sir, to give it to you, I have incurred 300 rupees. Can I recover that 300 rupees from him? The answer is no, you cannot recover. Because it's coming under past voluntary services, and it also comes under consideration must move at the desire of the promisor. I'll just ask you, did I tell you to come and give? No. That is what it comes under. So no, I'm not liable. I do not have a right to recover the money. But remember, you have one right. What? Until the money which belongs to you is paid, you have a right to withhold the goods with you. You need not return the goods until your lawful money is paid. But sir, can I sell the goods and recover? You can recover the goods by selling only in two scenarios. First scenario is when the owner cannot be found. Second one, when the owner is found, but the owner is rejecting to pay the money, and the value of finding the owner versus the value of the good, the value of the goods is 2/3 of the value of finding the owner. So imagine if to find the owner you have to incur 2/3 of the value of the goods. The product value is 1000 rupees. I'm incurring 800 rupees to find you, and you are not paying. I have a right to sell the articles and recover the money. Third one, if it's a perishable goods, I have a right to sell it. In no other case, when and all you can sell it, people, the first scenario is a owner cannot be found. Second one, people, is when the owner is found but rejecting to pay the lawful charges, and the lawful charges amounts to 2/3 of the value of the product. The third scenario is, people, is when it is perishable is done, perishable goods. In these three cases, people, you can recover the money. If not, you can just withhold the goods. But remember, if the other party has promised to pay you some reward, you can file a case that becomes a binding contract. Difference between bailment and pledge, important. Of course, I have not written rights, duties of everything, all that's it's like everything, the entire chapter is covered. But remember, in bailment, you can expect one case-based scenario. Pakka. Especially for that bailment for hire. Meaning, whenever there is any damages in the goods bailed, who will suffer the loss? So, the bailment can be of two types. One is free of cost, one is for money. Gratuitous, non-gratuitous. If it's free of cost, then, people, you are liable only for those defects which are known to you. If it is not known to you, then you are not liable. For bailment for hire, meaning for money, whether the mistakes are known to you or not, you are liable. There they can ask you a question. Important. Next one is reasonable care. If a bailment, if the goods are given, if you have taken reasonable care of the goods, remember, the bailee will not be liable. It is bailor's responsibility. Correct? I hope you understand. Yes? Okay. Next one, people, agency. Agency by necessity. Agent's authority in an emergency. Remember, that can be a important question. Ingada poichu macha. I'll show you that which one exactly I'm telling you. This one. This is important. To constitute a valid agency in an emergency, following conditions must be satisfied. First one, agent should not be in a position to communicate with his principal. Meaning, necessity means what, people? I am not able to communicate, and on that scenario, I acted. So, I will be considered as agent by necessity. There should have been actual and definite commercial necessity. For whatever actions I have taken, there should have been a reason for it. Third one, the agent should have acted bona fide, meaning in the best interest. My idea is not to cheat the principal. The agent should have adopted the most reasonable and practicable course, meaning whatever I did was the best I could do. I did not have an alternative. The fifth one, the agent must have been in a possession of the goods belonging to the principal. And when I did this, people, the principal's goods should be with me. If all these conditions are satisfied, people, there creates a agency by emergency or necessity. Remember this and go. Important. Next important thing they can ask you is agency by ratification. What is ratification? You already do of something. After you do, that particular act will become valid. Yes, sir, we would have seen our example also at the PG or that rent, probably renting of house example. Yeah, important from exam point of view. Remember and go. Ratification and necessity both important. Remember and go. Okay. Next one, ratification. Difference between sub-agent and substituted agent. What is the difference? Sub-agent. Principal gives the work to agent. Agent further gives it to another person. So this is called a substituted agent. Generally, people this is called a sub-agent. Generally, sub-agent is not valid. There is no doctrine of privity of contract. For whatever he does, I cannot hold the principal liable. always remember, delegatus non potest delegare, meaning what, people? You cannot, a delegatee cannot further delegate. I have given it to you, you cannot further give it to anyone. What do you mean by substituted agent? I will call my agent. My agent will say, sir, do one thing, you contact this person. He will give me the reference of this person. I will directly contact him. So here there is doctrine of privity of contract. So I will get, if I need to get money, I will file the case on principal. If principal, wants some clarification, he will directly file a case on me. Nowhere this person will be involved. But what will be the role of this person? His role is, people, to give a contact or a reference of a person with a due diligence. Meaning you should not be negligent in giving the contact. He should not be some random person. Yes. Next one, termination of agency. When will agency come to an end? This is also one of the points where they can question you. On completion of business, expiry of time. So where will this come? Termination of agency. All these will be easy questions, direct questions. Yeah. So when will agency come to an end? Effect of termination. Whenever agent gets to know, for him, agency will come to an end. Whenever third party gets to know, for them, whenever they get to know, agency will come to an end. Here they can give you a case-based scenario. The examination question can be picked from here. That is, even after a principal communicating to an agent that your agency services are no longer required, he still goes and does a contract. Is the principal liable for the third parties? Answer is yes. Until the third parties are aware, the principal will be liable to them. Remember, important from exam point of view, and go. Okay, done. Next one's Sale of Goods Act. People, 15 to 20 marks. Now, I'll always tell this in the class. Sir, Indian Contract Act, Dilka Darkan, but Sale of Goods Act, people, you need to be wise. You will get 15 to 20 marks. Yeah, Indian Contract Act, 9 units, 25-30 marks. Now, for all those people who keeps on saying, sir, I don't know, sir, I've left, sir, I'm not, now can I manage, sir? Remember, first concentrate on Sale of Goods and Indian Partnership Act. Because both these two chapters has a weightage of 15 to 20 marks, both. So if you see, Sale of Goods Act is 4 units, Indian Partnership Act is 3 units, both of it put together is 7 units. So minimum you guys can expect is 15 and 15. How much is minimum? 30, maximum 40, 7 units 40, 30 to 40 is the equation. There 9 units, 25 to 30 is the equation. Understanding, Anna? So try to focus these things first. Yes, all of you? Okay, Sale of Goods Act. Sir, in this, what are things? Classification of goods. Of course, all your existing future goods, contingent goods, all that are important. Existing goods can be further divided into specific goods. The goods which are decided at the time of contract of sale, which are identified at the time of contract of sale, is called as specific goods. Unascertained goods, bulk. Ascertained goods, something which is separated from the bulk. Future goods, the ownership or manufacturer acquisition will happen after the contract of sale. Contingent goods, which is uncertain, which is not sure. Document showing title, document of title. Document showing title is not the ownership. Document of title is the ownership. You lose the paper, you lose the ownership. Example, warehouse certificate, wharfing certificate, etc. Distinction between sale and agreement to sell. What is the difference there? In sale, the ownership is transferred immediately. In agreement to sell, people, it is on a future date. That's the main gist, if you guys remember. Of all the differences is important, that's why I took. So it will be immediately, it will be on a future date. Sale is always an executed contract because money, everything is done, contract is done, ownership is done, delivery is done. Agreement to sell is an executory contract. Today we have agreed that we will settle the contract in the future. The seller can sue for the price. The aggrieved party cannot sue, can sue only for damages. Meaning here ownership is transferred in sale. So I can sue the party for the complete price. But in agreement to sell, imagine if a person does a breach of contract. The ownership is not yet transferred. So I can just file a case for breach. I cannot, meaning I can only file a case for damages. I cannot file a case for complete price of the product because ownership is not yet transferred. Liability of parties, meaning after sale, if any loss happens to the goods, who will bear it? It will always, of course, sale, ownership is happened. So ownership is transferred. It will always be on the buyer. That is what is given here. Here it will be on the seller. Right of resale, here you cannot resell. Here it is still possible because the ownership is still with you. So remember that and go amongst all. Ascertainment of a price. How is a price ascertained? A price is ascertained always by the course of dealing between the parties. By agreement. If nothing is decided, the buyer has to pay what is reasonable. The fourth one is people by the third party evaluation. By the third party. Yes, the ascertainment of a price. Then conditions and warranties, macha, this chapter is important. They can pick you a question from any topic, especially implied condition and implied warranty. They can pick you a question from anything. So all that I can put is implied condition and implied warranty. They can ask you sale by sample law. They can ask you by title law. Yeah, chances of implied condition is little more when compared to implied warranty. Generally, I am telling you. Description and sample law, merchantability, wholesome law. Remember that and go. Exceptions to doctrine of K-weight tempter. I am not going in detail here because people, if you guys know this, it's the same here also. Correct? So remember these and go. Especially pay more focus to implied conditions. That is very, very important. Hey, understood? Yes or no? Okay. Now when I'm doing this, you should be like, yes, sir, I know that. Oh, that, sir, that we know. Oh, this, sir, this you leave it to us, sir. That we should be telling. Yes, sir. Okay. Next one, transfer of ownership and delivery of goods. When does passing of property happens? People, this is also very, very important. Types of goods. When does the ownership pass? Here also they can build you some case-based questions. Passing of property. Yeah. So for this, what I will suggest you is directly open the marathon and sit. This part. Yeah. They may ask you, and I'm telling you the chances of this coming as case-based question is more. And this sale or return basis. In sale or return basis, what is equivalent to an acceptance? These scenarios. A person signifies an approval, a person retains the goods beyond the return period, or something does something equivalent to an acceptance. They can ask you a question there. Yeah, so pay more attention there and go. These parts. Clear? Okay. Sale or return, transfer of title by non-owners. Transfer of title by non-owners is also one of the question. This one. Generally, who can sell it? Owners can sell it. Non-owners can also sell it when people, if it's sold by an agent, of course, on behalf of the principal. One of the joint owners. If two people own the product, one person in them can sell the product. It is valid. Sale by person in possession under voidable contract plus contract is not yet rescinded. They can ask you a case-based question on this topic. Remember, this is important. Case-based scenario, this is important. Sale by person obtaining possession before property, okay, they will not ask you. Sale by, this is also important. Exam point of view. Especially these two, they'll ask you a question. If they're asking case-based scenario. Sale by person who has already sold the goods but continues in possession. Buyer acted in good faith. This is also important. Remember and go from exam point of view for the case-based scenarios. Okay. Last one, sir, unpaid seller, termination of lien, situations when the transit comes to an end. When does the transit comes to an end? So these two topics, know and go. Termination of lien and when does the transit come to an end? Termination of lien, when does lien come to an end? Delivery of goods to the carrier or bailee without reserving the right of disposal. When the goods are given, it's done. Buyer or his agent obtains a possession. You have taken the goods, it's done. Seller waived right of lien. I give up my right. Estoppel. Estoppel is again something equivalent to giving up only, where based upon my conduct, I will show as if I will not take any action. This thing will come to an end. Next one, when does transit comes to an end? This also I can ask you. When buyer or bailee obtains delivery, carrier or bailee acknowledges to the buyer that he holds goods for him and seller has not reserved the right of disposal. Goods delivered to the carrier hired by buyer refuses part delivery. Remember, this one go. It's clear all of you. And in this, what else? Difference between right of lien and right of sit. When right of lien ends, right of sit starts. Right of lien is right to retain the possession. Right of sit is right to regain the possession. And what is that? When right to lien ends, right to sit starts. And right to lien can be exercised in many scenarios. When the money is not paid, or when a person becomes insolvent. But right to sit can be exercised only when the person becomes insolvent. So remember that and go, important. Effect of subsale or pledge by the buyer. Remember that, sir, whenever there is a seller who has agreed to sell goods to one buyer, he has further agreed to sell the goods to another buyer. The question is, sir, if my money is still not paid, the first seller's money is still not paid, will this person get a good title? Generally, people, if the person does not receive the money, whatever the subsale will be considered as invalid only. Meaning, I can still exercise my right to lien, right to sit, unpaid seller rights, whatever it is, I can still exercise it. But it has certain exceptions. What is that exception? If I have agreed for the subsale, whether directly or based upon my conduct, then people, my right of unpaid seller will come to an end. That is one thing you need to remember and go. And the last one, of course, auction. The chances of direct question coming is always there. It's a direct question. Clear all of you? So know these and go, sufficient. Next one, sir, see 15 to 20 marks, Indian partnership, 3 units. In that first and 3 is bakwas, nothing is there. Second one, I know, little tricky, but nothing is there, 15 to 20 marks. Remember, you should be a master in Sale of Goods Act and Indian Partnership Act. Okay. First one, people, true test of partnership. Meaning, people, just a sharing of profits is not sufficient. There should be mutual agency, there should be separate bank accounts. They should be registered. Partnership can be registered or unregistered. So all of that will be considered the true test of partnership. It should not be like just a person giving money. It can be remuneration. It can be widow pension. It can be considered as interest. Especially the question will come under what is that? Co-ownership. Case-based question will come most of the scenarios under co-ownership. Meaning joint owners of a property. They will ask you, is it considered as partnership or not? It is not, because there will be no business activity. Only sharing of profits are happening. So only sharing of profits is not considered as, it's not considered as what? It is not considered as partnership. That particular point is important. Remember and go, especially co-ownership. Difference between firm, LLP and company. Remember in our class we have written in one last, when you're doing company, everything comparison. That is important. Remember and go. One question can come between any two. They will not give all three. Types of partners. When the attempt is very easy, they will ask you this. Especially it can come under active or nominal partner generally. Or partner by holding out. Case-based scenario. And remember, partner by holding out. A is a partner by holding out. I represent as a partner in front of B. Only to B I will be considered as partner by holding out. Imagine if B went and told someone, some person called C, another outsider. For C, I will not be considered as partner by holding out. With whomsoever I made a direct representation, I will be considered as partner by holding out. They can ask you a case-based scenario here. Remember, important and go. Clear? Okay. Unit to relation of partner, right to remuneration. Can you get right to remuneration? Your agreement has to provide. If not, it can be customary. Meaning if you have followed the practice of paying remuneration every year, if it has become a custom in your thing, then yes people, you can go ahead, you can pay remuneration. That part they can ask you a case based question. Right to share profits, how will you share? Right to share profits will be as per your sharing ratio. If your ratio is silent, then you will always share the profits equally. Possible question. Personal profits earned by partners, very very important. If at all it is competing business, same line of business, then people, whatever money you made, you have to return it back to the partnership firm. Second one, people, if you have made any money using the partnership's property, partnership's network, partnership's name, in such cases, people, whatever is the money made, you are accountable. You have to give it back to the partnership. Remember, people, what is the end line? Summary is that a partner can never make secret profits. Remember and go. Next one, implied authority of partner. What cannot be considered as implied authority? Opening bank account in your own name, transferring, selling or buying of immovable property, admission of disputes, taking the cases under arbitration out of the court settlement, admission of liability in the court, withdrawal of suit, all this cannot be considered as implied authority. Liability of firm for misapplication by partner. If a partner does any mistake, if he misappropriates money, meaning he is doing a fraud, the partnership firm is liable to the outsiders, but the partnership firm can recover the money from the partner who did the fraud. That's a secondary story. But for outsiders, we are liable. That is this. Rights of transferee of a partner's interest. Very, very important. They will ask you a case-based scenario. There is A, B, C partnership firm. C transfers his share to D. What will be D's rights? D's rights, you can get profits, absolutely fine, but you cannot involve in day-to-day affairs of business. You cannot inspect the books of accounts. On the day of dissolution, you will be entitled for all the books. Correct? And remember, A and B, they are not okay. A and B can also go and ask for dissolution. This is also one of the ground for dissolution. Minors, remember, so upon your majority or within maximum period of 6 months, whenever you get to know, or 6 months, whichever is later, but subject to maximum period of 6 months from the date of you attaining majority, you have to give your decision of whether you want to continue as a minor or not. Very, very important, they can ask you a question. And remember, whenever a minor, if he decides to continue, then he will be liable for all the contracts that was entered by the company, that is entered by the partnership, since he was admitted as a beneficiary. From that day he will be liable. This is the only exception for ratification in minor contracts. You will be liable from that day. Is this clear? Okay. And as long as you are a minor, people, of course you cannot sue the partners for accounts and all, but upon the day of dissolution you can sue the partners for your accounts. That is possible. And until you guys decide whether you want to come out or not, until that 18 years 6 months, you will still be treated as minor only. And whatever your share will be same before, whatever is that will continue. Right of outgoing partner in certain cases to share subsequent profits. What is this, people? Whenever there is an outgoing partner, imagine death and all, if you have not settled their money and the partnership firm still continues the partnership firm without settling the money, then people, whatever the profit sharing ratio, they will be entitled to that. If not, people, they will be entitled for 6% rate of interest for the money that you have used, which you guys should have settled. They can ask you a question there, remember and go. Consequence of non-registration, of course, is simple one. Again, I am not going in detail. Difference between dissolution of firm, dissolution of partnership. Dissolution of firm is a dead end, meaning entire firm only is coming to an end. Dissolution of partnership is a new partner coming in, new old partner going out. So it's a reconstitution, correct? So here realization of assets happen, here revaluation of assets happen. Dissolution of firm will result into dissolution of partnership also. Dissolution of partnership may or may not resolve in dissolution of firm. Dissolution of firm can be done voluntarily or even by court's order. Dissolution of partnership does not require court's order and all. Modes of dissolution, people, how and all it can be done. Dissolution of firm. So one is voluntary, one is by court. Voluntary dissolution by agreement. Compulsory dissolution is when you guys become insolvent or whatever business you guys have been doing becomes unlawful. It's my water. Okay. Happening of any contingencies. Contingencies means what? You said upon this thing happening, we will come to an end. That thing happened. You may continue or it may come to an end. Dissolution by partnership at will. Partnership at will means, people, whenever a partner gives an intention that let us wind up, let us wind up. Dissolution by court, insanity or unsound mind, but remember it is always an active partner. See, these are the points where they can ask you a question. If it's a sleeping partner, no. Permanent incapacity, like physical disability and all. Misconduct, they can ask you whether it is something which is in the business or in the personal. In your personal life, something happened. If it is affecting the business, that is also one of the ground. Breach of agreement, transfer of interest to third party. See, continuous or perpetual losses. From the last two attempts, they have been asking a case-based scenario from dissolution by court. Remember and go. They are asking a case-based scenarios from dissolution by court. So remember and go, important from exam point of view. Yes? Okay. Macha, this only. Very, very important. One chapter, chiller topics, 5 to 10 marks. You can easily predict the question. Know this and go, you will pakka get. Pakka. What is that? First to know financial year. What is financial year? Sir, generally 1st April to 31st March. But only exception on the date of incorporation in the first year. If at all you are incorporated on or before 30th September, let us imagine 2025. My financial year will be 31st March 2026. If at all my company is incorporated on 1st October 2025, then remember my financial year will not be 31st March 26, my financial year will be 27. So in a company, the date is 31st of December. If a company is incorporated on or before 31st of December, then you will immediately wind up the financial year in the next year. But if your company is incorporated after 31st of December, meaning 1st of January, then your financial year will end on next financial year. In the LLP, people, that date is 30th September. So 30th September you are incorporating, your financial year will end just like the same financial year. If you are incorporating after, then your financial year will end 27. So remember this and go. Small LLP, people, contribution 25 lakh, turnover 40 lakh. Partners, designated partners, minimum 2 partners are required. If the number goes below 2, then the LLP should make sure they increase the number to 2 within 6 months. If not, people, whoever are the partners who are aware of the fact that our LLP is functioning with less than 2 partners, such case, people, they will be personally liable for the contracts entered in that particular period. And remember, failure to admit or failure to have minimum number of partners beyond 6 months is also one of the ground for dissolution of LLP. Next one, designated partners. A company shall have minimum 2 designated partners. Designated partners are always individuals only. But remember, if at all, whenever a body corporate is partners, 2 body corporate are partners. In such case, then how will we have designated partners? The body corporates can nominate someone as nominee and they will be called as a designated partners. There should always be at least one designated partner uh, who is a resident in India. That is 120 days condition is to be satisfied. That is, a person should have stayed during the financial year at least 120 days. That condition is important, remember and go. Next one, features of LLP, same like company, most of it. Remember that and go. That is important. And incorporation stage. You need to file Form Philip with all the details signed by professionals. If everything is properly given, LLP will be registered and ROC will give you certificate of registration. Remember this much and go, more than sufficient. Yeah, very easy way to pick or get the marks here. And anyways, we have already seen the difference between LLP, firm and company. So that is also covered. So then kaiku tension. Okay, next one. Companies Act, look at the weightage. Yeah, but of course it has concepts also. So I have tried to, chart down these things. Of course, everything is important, but yes, I cannot say everything read. Don't miss to see small company and go. Small company is a company paid up other than public company who's having a paid up capital not exceeding 4 crore and turnover not exceeding 40 crore. A subsidiary company, holding company, section 8 company, statutory company cannot be called a small company. Government company definition, a company where central government and state governments hold 51% of total capital is called government company. A subsidiary of a government company is a deemed government company. OPC. Who can nominate, who can be OPC, the entire rules are read and go. Private company, the three conditions, very important. They can ask you a question from private company, subsidiary company and all is very important. Yeah, the three conditions. What is subsidiary company? A company who controls the composition of board of directors, a company who has who holds minimum more than 1/2 the total voting power, either on its own or together with its subsidiaries. Third one is deemed subsidiary company. Associate company. What is associate company? When one company has more significant influence in another company, is called associate company. What is significant influence? At least 20% of the total voting power, but not a subsidiary company. It includes a joint venture. Remember and go. Dormant company. What is dormant company? Inactive company. A company which is inactive or a company which is formed for the purpose of a future project or to hold any asset, and a company which does not have any significant accounting transaction is called as dormant company. Public financial institutions, what is PFI? Generally today we have LIC, IDFC, UTI. What is the criteria that we consider to call someone PFI? It should be either a statutory company, government holding 51%. These are the conditions. And of course, people, all the doctrines. Doctrine of ultra vires, constructive notice, indoor management, exceptions to indoor management, know that and go. And entrenchment of articles and all, pay more attention. So these are some things, especially these definitions are something where they will ask you questions again and again. So do not forget to read that and go. Small company, government company, subsidiary company, private company, associate company. Very important. This is clear all of you? Pakka? Okay. Last one, sir. Negotiable Instrument Act. Essential characteristics of negotiable instruments. Know the characteristics. It should be in writing or stamped. It can be freely endorsed. All that. It should be cash only. Difference between promissory note and bill of exchange. People, difference between question will be there. Pakka it will be there. We'll always think. Sir, imagine if the difference between question is for 5 marks. How many points are we supposed to write? People in your book, if they are given 7 points, you are expected to write 7 points. So never end your answer with 5th point even if you know. So if you know all 7 points, write all 7 points. Whatever is there in the book, we are expected to write. Is this clear? Okay. Inland and foreign instruments are very, very important. What is inland and foreign? See, again I should do. We have done it so many times. Yeah. If a bill is drawn in India and see this condition should be satisfied. If this only has an into mark, then it done. If a bill is drawn outside India, it is always a foreign instrument. So bill is drawn in India, payable in India, or drawee resides in India. Remember, question coming from this indirect based question is also there. They may ask you, yeah, sir, this condition satisfied, both these not satisfied. It is called foreign instrument. Sir, main condition only not satisfied, foreign instrument. So, sir, at least one, sir, it is called as an Indian instrument. Clear all of you? Pakka? They can ask you that. Inchoate meaning incomplete instrument. When presentment is unnecessary and rules of compensation. People, this they have asked questions a lot of times. Again, I'm telling you, go for marathon. Watch this. You will get a clear-cut idea. And this is something where they have been asking indirect based questions. And you can expect indirect question here. And of course, they can ask you check. But yes, for now, this should be sufficient. Yeah. So people, this was an attempt to make sure that we cover most important topics from your exam point of view. Last second, don't leave these things and go. Very, 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 very important. And do let me know after your exam is done. How did your exam go? I'll be one of the most happiest person to celebrate with you. Yes. So that was for today. In our tomorrow session, let us take up the entire case law series of ICAI syllabus. Whatever is given in your ICAI, let us try to do the entire thing. So thank you so much. See you all. Bye bye. And see, this is one thing I have to say. It's an only attempt to cover the key and most frequently repeated topics. Please don't rely solely on this. Yes, all of you. Chalo. Thank you so much. See you all.